SJC-12074, Commonwealth v. Alexander Soto.
Good morning, Ms. Saxey. Give us a moment. And you may proceed.
Thank you, Your Honor. Good morning, and may it please the Court, Hilla Saxa on behalf of the Commonwealth. With me are Assistant District Attorneys Mark Halal and Montez Haywood, who are the trial prosecutors in this case. And I would also like to acknowledge the presence in the courtroom of James Lawton with his family and of the family of Ryan Morrison. We are asking the court to vacate the order of dismissal and to reinstate the non-murder indictments to the docket of the Superior Court.
Can I ask you, that was dismissed without prejudice, right?
That is correct, yes.
So the Commonwealth could seek to go to juvenile court and get the indictments.
Not indictments.
I mean, I'm sorry, could go
No,
to juvenile court and file a complaint as to one of them, and as to the other three, seek a grand jury indictment as youthful offenders, right?
No, because he's over 19. He's 19.
So it can't be done anymore?
At this point, it could not be done. However, the juvenile court does not have jurisdiction over the person of Alexander Soto. Murder is the only crime in Massachusetts for which a person under the age of 18 is treated as an adult. And Chapter 119, Section 74, indeed divests the juvenile court of jurisdiction over the person charged with murder.
No, I appreciate that that's the argument, but I'm just wondering what the impact is here on the Commonwealth of the Judge Laureate's decision. Is it that you cannot bring the non-murder indictments anymore? Are they done? Is that the reason that the Commonwealth is here?
Your Honor, the reason the Commonwealth is here is that we believe the indictments were dismissed in error, that they need to be reinstated as Superior Court adult indictments.
If they're not reinstated, then what happens?
Your Honor, at this point, the defendant has turned 19, so the procedure outlined in Section 72A would apply. However, that is simply not applicable here, where the juvenile court does not have jurisdiction over this person. And where Section 74 speaks of jurisdiction for anyone charged with murder and related offenses, or those that are properly joined, the person cannot stand in two different courts at the same time, where the juvenile court, in fact, has no jurisdiction over him. So he could not, at the same time, be proceeded against in the juvenile court for indictments that are properly joined with the murder.
If the Commonwealth had chosen to go to juvenile court,
The Commonwealth could not have chosen to go to the juvenile court.
Didn't that happen in other cases?
Your Honor, I'm aware that there has in the past been practice where these indictments, non-murder indictments that are related to the murder, have been dismissed, and the Commonwealth has, our office in the past has indeed proceeded down that path, but that was at a time where we did not have the benefit of this court's clarifications in Walchak, and where the law was simply not, I believe we simply reconsidered our position on this and our interpretation of the law as it stands. And in fact, the Commonwealth cannot proceed in a case like this in the juvenile court.
Because you're saying the Superior Court has exclusive jurisdiction?
That is what the statute says. The Superior Court has jurisdiction over the person who is charged with murder and over all related offenses.
Where does the statute say that?
I'm sorry,
Go ahead.
Go ahead, please. Justice Link.
Oh, I was just going to say, and where does the statute say that?
So the statute says that Section 74 divests the juvenile court over jurisdiction over the person charged with murder, and that complaints and indictments brought against persons for such offenses and for other criminal offenses properly joined. So a person standing in Superior Court on a murder indictment cannot at the same time be proceeded against for properly joined offenses in the juvenile court, because the juvenile court has no jurisdiction over that person solely for the purposes of the murder and related offenses. If the same person were also charged with an unrelated crime that, say, something he committed shortly before he was arrested, which has nothing to do with the murder, that the juvenile court would have jurisdiction over those offenses, but nothing that is connected to the murder and properly joined with the murder indictment.
That to test whether it can be properly joined?
I believe the test properly joined, it considers the regular joint.
My question is as to the non-murder incidents.
Yes.
You're saying if they could not be properly joined with the murder, then it's okay to go to juvenile court for those?
For indictments that could not be properly joined, absolutely, yes.
Okay, so that was the question. Is that how we would tell which ones could and could not be within the exclusive jurisdiction of the Superior Court?
That is correct, yes.
Okay.
And the Commonwealth, as mandated by Rule 9A2, would seek indictments on all related charges under one indictment number, as was done here, as is done in any adult case, as has been done in cases of juveniles convicted of murder that this court has affirmed under its 33E review.
But you don't disagree that there have been cases of murder where the Commonwealth has followed the procedure that the defendant is arguing for here? I mean, certainly, and you don't need to restrict your answer to Suffolk County. I mean, I just think...
I'm only anecdotally aware of other cases from other counties. I know that there's one case in which Suffolk County has followed that procedure, but it was over 4 years ago, and the reasoning is simply, the reasoning was in that case in order to preserve the sentencing options of that the youthful offender statute provides. And but if the court reads Section 72B, those sentencing options are indeed available to the Superior Court if a
Well, let's go there though. 72B says if the defendant is found not guilty of murder, the Superior Court judge can sentence in accordance with Section 58, right?
That's correct.
And 58 then makes reference to there having been a youthful offender indictment, doesn't it?
Section 58 is the youthful offender sentencing statute. However, Section 72B mandates the Superior Court judge to sentence in accordance with Section 58. So a Superior Court judge could never sentence on a youthful offender indictment simply because a youthful offender case would not take place ordinarily in the Superior Court. And in accordance with simply means that it opens up the Superior Court judge to exercise his or her discretion in taking the defendant's age into account when sentencing on non-murder convictions.
Go ahead, please finish.
No,
What about if you take the appellee's position, though, which is that it's Section 54 that really controls how to proceed against a juvenile when the charge isn't murder, correct?
yes.
Okay. And then as far as how you deal with related charges, that's dealt with in Section 52 through Section 63. So you don't have to look at Rule 9 and 72 and 74 in isolation. You could also look at it from the perspective of the appellee, which is you start with Section 54, and then you sentence pursuant to the procedures in 52 to 63, and that's how a youthful offender would be sentenced. And the way to deal with that is to get a youthful offender indictment and have the case transferred to the Superior Court.
You know, I would like to respond in two parts. First of all, my brother's argument fails for right at the outset because he reads Section 74 as simply conveying jurisdiction over the charge of murder to the Superior Court, not over the person of the juvenile charged. And that is a significant difference, I submit. And in addition, I think no matter which procedure the court were to follow, whether there's straightforward Superior Court indictment that the Commonwealth advocates for, or the somewhat circuitous route through youthful offender indictment, interdepartmental assignment, et cetera, that my brother advocates, we all end up in the same place.
Well, do we? So explain this to me. So
Yes,
let's say that there's a jury verdict of not guilty on the murder. And let's say that the indictments were not youthful offender indictments, okay? And certain findings have to be made for there to be a youthful offender indictment. So certain presentments that go into a youthful offender indictment beyond just the charge. So now the case is in the Superior Court, and the jury came back on an armed robbery, an armed assault with intent to murder, whatever it might be, with a guilty. How do you sentence?
In that case, the Superior Court judge would sentence in accordance with Section 58. If there's no guilty verdict on any murder, but of course we only get there if there was a murder indictment.
I understand.
Yes.
And what do you do with Section 54 that sends you to Section 52 through 63 as to how to proceed against a juvenile for non-murder charges?
Your Honor, where there is a murder indictment against a juvenile, Section 54 simply does not come into play because the person of the juvenile is removed from the juvenile court for the purposes of these charges.
Well, help me on that. So let's assume for some reason that the Commonwealth didn't charge him with murder.
Did or did not?
Did not.
Yes.
And charged him only with the other offenses. He'd be in juvenile court.
Of course.
And charged as a youthful offender except as to the firearm.
Correct.
Correct. And when the jury heard that case, the jury would have to, with regard to the youthful offender indictments, find not only the elements of the offense, but also the two elements of the youthful offender provisions.
Correct.
In the if you were to prevail at the adult trial, would the jury in Superior Court also have to make those two findings to find him guilty of what would otherwise be the youthful offender charges? Are the elements the same in Superior Court as they would have been in juvenile court?
The elements are not the same because Section 72B says that where there is an allegation of murder, the person so charged, the juvenile, is entitled to an indictment under Chapter 263, Section 4, which is the general indictment statute. And a person in that case, the person will be indicted just like an adult. If the grand jury returns with a murder indictment, the person of the juvenile then is an adult, treated as an adult for all intents and purposes, as Justice Lenk voiced in Walczak. At some point,
But I guess the question is, why should that be? I mean, I understand why he is being charged and treated as an adult in the sense of the trial being held in Superior Court, but why should, especially where he's found not guilty of the charge that got him to Superior Court, why should he not be entitled to the same elements that he would have had he been in juvenile court? Why are the elements to be different? Why would a Superior Court jury not have to find that the offense involves the infliction of or threat of serious bodily harm as the jury would have to find in juvenile court?
Well, first of all, because the legislature chose to take one crime in Massachusetts and open it up for adult treatment of a person under the age of 18, over 14, under 18. If for some reason age were an issue in the indictment process, the juvenile, for example, is only 13, he could file a motion to dismiss and saying, I'm I don't fall under Section 74, and a Superior Court judge then would have to find, probably hear evidence and make findings on the age. And in that case, if it indeed turned out that an indictment had been returned for a juvenile or a child of the age of 13 or younger, then that charge would have to be dismissed. Here, the defendant
it would have to be dismissed in Superior Court, or would the judge simply have to sentence him as a juvenile?
No, no one under the age of 14 can stand trial in the Superior Court. That would have to be dismissed, and it would be a delinquency complaint in juvenile court.
And that question the Chief asked you about the added elements that would not take place in Superior Court, would that be the same scenario were the defendant to be transferred pursuant to the authority of the CJIM as advocated by your brother?
Your Honor, that presumes that a youthful offender indictment had been returned, which requires the added elements to be presented to the grand jury.
Right, but I'm talking about the trial.
Yes, it would be different because the transfer, the interdepartmental assignment does not confer jurisdiction over the case to the Superior Court. It simply puts a second hat on the Superior Court judge, who will then sit as a juvenile court judge.
Right,
So
but
what I'm trying to get to is, at the end of the day, were the procedure that your brother advocates followed as opposed to the procedure you advocate, would a defendant have those extra elements be part of his or her case
in the Superior
in the
Court.
Superior Court?
In a Superior Court where he is being tried as a juvenile.
But no, he's
Anyone
being
tried-
tried for murder, but
Right.
but he has these added charges accompanying it.
Pursuant to a transfer, right.
In other words, he can't be a youthful offender without these other elements. It's not enough that it's a armed robbery.
Maybe she,
You need these other elements.
Yes, well, if he were tried on youthful offender indictments, these elements would have to be met. At the same time, however, he would still be tried for murder, and these elements would not have to be met except for the fact that the defendant can challenge the indictment based on age at any time.
Right. And
it is a general practice. It was done in this case that the age of the juvenile is brought to the grand jury, and the grand jury knows.
I'm just trying to flesh out the differences between what you propose and what your brother proposes at the end of the day, where someone's going to be standing in Superior Court facing, of course, the murder charges. Now they're facing the armed assault charges or the home invasion charges. What's going to be the difference at the end of the day?
Yes, in the end, the murder indictment is what controls. It is the most serious crime, no matter how serious any of the other indictments are, and the legislature has decided.
No, I understand your argument about
So,
statutory construction.
If I could add that the adding elements to sort of lesser offenses in order to protect anything doesn't really help the juvenile, because the legislature is treating him, has decided to treat him as an adult. And this court has affirmed convictions of juveniles charged in the Superior Court of murder and related offenses, such as firearm offenses as here, and assault and battery, dangerous weapon, under its power of under 33E. And those cases are Commonwealth versus Jackson, for example, Commonwealth versus Ray. And this is a very simple, straightforward process. In the end, the defendant, if he's not convicted of murder, will receive the same benefits as if he heads to trial as a youthful offender, because the sentencing options of Section 58 are opened up to the discretion of the Superior Court judge, who will be able to take into account any mitigating circumstances as relating to age or the nature of the offense, et cetera.
Okay, thank you.
Thank you very much.
Good morning.
Mr. Chief Justice, and may it please the court. Let me begin by answering Justice Lenk's question, which is that if this court simply affirmed the dismissal and took no other action on this case, the Commonwealth would indeed be able to go forward against this juvenile They could simply obtain juvenile delinquency complaints and youthful offender indictments and
Well,
move under
complaints,
72A
you
to
wouldn't get the
transfer.
youthful offender indictments, but you'd get the complaints, and then they could be dismissed and then transferred to Superior.
That's true, that's correct.
So it would just be via the transfer proceeding, and that's what you were complaining about as, what the, you were, I think, mentioning that in the brief as something to be avoided.
I think that that would be an unfair result in this case because essentially that transfer procedure would result in adult criminal charges against Mr. Soto, which is exactly what the judge dismissed.
So as a practical matter, what is the difference, since put aside this case, but let's assume that you're just comparing what would happen to somebody who would go through the procedure that you are advocating for and the one that Ms. Sachse is. At the end of the day, if the defendant is found not guilty of the murder and guilty of one or more of the associated offenses, and the Superior Court judge, you say the Superior Court judge does not have the options, if we go with the Commonwealth's view, doesn't have the sentencing options that would be available if that transfer proceeding or had been followed?
Well, the Section 72B says that if the juvenile is found not guilty of murder, the judge shall enter a sentence the Superior Court judge shall enter a sentence in accordance with the provisions of Section 58. There's two kinds of sentences that can be imposed under Section 58. One is a commitment to the Department of Youth Services
Yes.
till the age of 18.
Yes.
The other is where it has been presented to a grand jury and proven beyond a reasonable doubt the youthful offender elements, then there are three other sentencing options, which is a sentence provided by law, or a combination sentence, or a commitment to the Department of Youth Services till the age of 21. But those options are only available once the
But
youthful
couldn't
offender
you
elements have
read the
been-
statute as meaning that the options would be available in this particular circumstance?
Well, I don't think that it can be because those, again, going back to Section 58, if the judge is sentencing in accordance with Section 58, he can only impose those sentences upon an adjudication as a youthful offender under the terms of Section 58. And under Quincy Q, which was interpreting Apprendi versus New Jersey, those youthful offender elements are indeed elements of the offense which have to be charged and proven beyond a reasonable doubt.
So what would happen if we allowed joinder of these cases but required the jury to find those elements of a youthful offender?
I think that, well, with the exception of the charge that's not a felony,
Firearms, right.
Right.
I think that would be actually the correct result. They should be, there's no
That's
issue
not what you're
that-
asking for. You're asking for a youthful offender indictment. What I'm suggesting is that or the possibility that we say, okay, joinder means that they can be tried in Superior Court, but your client will not be denied the benefit of the additional elements of a youthful offender, and the jury will have to find those elements at trial,
Yeah.
even though he was not indicted as a youthful offender. And if the jury were to find him guilty as a youthful offender, then he could be sentenced as a youthful offender. If they did not, he'd be sentenced as a juvenile.
I think that would be correct, Your Honor, actually. And although the Commonwealth did not present that to the grand jury, there was certainly sufficient evidence before the grand jury to have obtained indictments
So the
that
cases
stated those
were
offenses.
improperly dismissed in that event.
No, the cases were properly dismissed. I just think that that's the only fair option that remains to the juvenile. Here, the Commonwealth, this case was dismissed over a year before Mr. Soto's 19th birthday. The Commonwealth had plenty of time to obtain those indictments and didn't. And if the dismissal is simply affirmed at this point and the Commonwealth goes and gets juvenile complaints and they're transferred to the adult court, in essence, the juvenile has been placed in a worse position by the
Well,
courts
no, because
affirming the
the
dismissal.
juvenile hasn't been tried yet, right?
That's correct.
So, if the juvenile is tried on these indictments and this court requires that the jury, the trial jury, find beyond a reasonable doubt the elements of youthful offender.
I think that's fair. In essence, that would be treating these indictments as if they were youthful offender indictments.
Well, right,
And-
but it doesn't involve going back, that whole.
I think under the circumstances of this case,
Well, but how about on circumstances of any case?
I think typically what has to be done is that the indictments have to be brought as youthful offender indictments, and then they have to be properly joined. No one says that you have to necessarily go to the juvenile court. I do realize that below, Mr. Soto argued that the indictments had to be brought in the juvenile court, but indictments are brought by grand juries, not by the juvenile court. As long as the indictments are brought as youthful offender indictments, I don't see any problem with the proper joinder. And I'm not even sure that the 211 procedure of necessity has to be followed, except to the extent that the Superior Court judge needs to be vested with the authority to exercise the powers of a juvenile court judge, which is what the Chapter 211B allows.
What, just clarify something for me. If the defendant were convicted of the murder and one or more of the associated offenses, you don't argue then that the sentence would have to have the juvenile, do you?
Oh, I do. On the non-murder offenses, again, I still believe, regardless of whether he's convicted of the murder, on the non-murder offenses, in order to sentence on those, I believe that the statute isn't clear as to what happens. It doesn't say if he's acquitted of murder. It doesn't say if he's convicted of murder how the sentence should be imposed on the non-murder offenses at all. 72B is really silent on that issue. But where 72B is silent on that issue, I think the rule of
So if
lenity.
someone's been convicted of first-degree murder, then you have to have additional element as to whether or not they're dangerous?
Not as to the sentence on the first-degree murder, but as to the sentence on any other crimes of which he was convicted. And the reason for that is that the Commonwealth argues that it doesn't make any difference. The first-degree murder sentence trumps all because it has a long period of
Yeah, well, obviously you need to, the other sentences have to have validity.
Right, and the other issue is it depends on whether there are being consecutive sentences imposed and when those sentences begin to run, whether they run from the end of the parole period. So there are issues, whether he's convicted of first-degree murder or not, whether he's treated as adjudicated as a youthful offender or convicted as an adult on any of the related charges does potentially have an effect on how long, one, on his sentence, and two, on how long he is to be incarcerated. The other aspect that I did wish to address, the Commonwealth argues that in Section 74, that it says that it's the jurisdiction over a person. And there is a sentence in Section 74 that it says that they have jurisdiction over a person, and then it says that complaints and indictments that are properly joined are to be brought in the usual course and manner of criminal proceedings. And the Commonwealth, however, says, well, if it's an unrelated charge, then the juvenile court does have jurisdiction over that person. Well, the juvenile court either has jurisdiction over the person or jurisdiction over the offenses. If it's jurisdiction over the person under the Commonwealth's theory, reading of Section 74, once somebody has been charged by the Commonwealth with first-degree murder, any other charge which has ever been brought against them or is to be brought against them that arises while they're a juvenile would have to go to the Superior Court, and that can't be
No,
right.
that's not how they're reading it.
It's only
Aren't they-
Rule 9.
Yeah, it's only those that are properly joined under Rule 9.
Well, that's not the sentence that they're relying on. The sentence before says that there's jurisdiction over the person, and the following sentence talks about, which is the same language that arises in Section 54, talks about properly joined offenses. And so I would argue, I realize that that's not what, if they're correct, that the juvenile court loses jurisdiction over the person, and all jurisdiction over that person is vested in the Superior Court, it can't possibly be limited to related offenses, the way that that statute is written. If the court doesn't have any further questions, I'd rest on the brief.
Well, so you say if we accept your argument, you want half of it, but you don't want us to go all the way because you don't want to have this defendant end up in the same place he would, which, because he's 19, would mean that he would end up in the same place, right?
In essence, what I seek to avoid is for the Commonwealth to profit by having appealed a dismissal and having that dismissal affirmed. And that would be unfair. Had the Superior Court judge, ordered that they were dismissed without prejudice to the Commonwealth obtaining youthful offender indictments and a juvenile delinquency complaint on the non-youthful offender charge. More than a year before this juvenile's 19th birthday, the Commonwealth chose simply not to comply with that order and instead to appeal the order. And as a result of the Commonwealth's appeal, now, more than a year later, if this court affirms the dismissal, now the juvenile is set in a position that would make him worse off. So in essence, the Commonwealth will be able to obtain exactly what it wasn't able to obtain at the time.
Yes, but if they're right, appeal was the only way that they could make that point, right? I mean, if they had just simply gone forward to juvenile court, the matter would be unappealable. And
yes,
the question would not be raised about whether or not this was the correct procedure.
that's correct, but
So it's not a choice that, I mean, are you saying that that somehow the Commonwealth behaved in a way that was dragging its feet, or we've suggested in other instances that there are problems if that could be shown, but that doesn't seem to be the case here.
I'm not suggesting that there's bad faith. All I'm suggesting is
By the choice to appeal, that somehow that wreaks an unfairness?
that it does give an unfairness in the sense that the Commonwealth basically, by appealing in this case, and I'm not saying it was done in bad faith, but by appealing in this case, the Commonwealth put itself in a position which is, if it wins the appeal, the juvenile is tried as an adult on the non-murder offenses. If it loses the appeal, it can then go back to the juvenile court and obtain transfer and try the defendant as an adult on the non-murder offenses.
In that, right?
Excuse me?
A certain similarity with Mr. Mogolinsky with that.
To some extent, that's correct, although there's a longer period of time here. So I think that's the unfairness.
There's something unfair about having, as a result of an appeal with some basis, to then have the result be that the non-murder charges would be dismissed, right? I mean, there'd be no way of proceeding on those, right? Or would there?
What I would suggest, and I think in the court's supervisory authority, is I think a correct remedy, which Justice Gantz
So you'd favor
suggested.
that remedy?
That simply the indictments be treated as youthful offender indictments.
Not that they would disappear, it's that they would be dealt with differently.
That's correct.
Okay.
Okay, thank you.
Thank you.